law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey everybody, welcome to the Law of Self-Defense News and Q&A show for August 12th, 2021. If I could get a quick audio check from somebody in the comments, that's always appreciated. Should be working okay, but we're legal experts, not technology experts, so it can be hard to tell. Just one comment will do just fine, folks. Come on in, make yourselves comfortable. We have a full show for everybody today. In just a moment, I will step through. Thanks, Dwayne. Audio seems to be good. I will step through just a quick overview of the topics we plan to cover today. Obviously, this is the Law of Self-Defense News and Q&A show. For anybody who may not know, I am attorney Andrew Branca for Law of Self-Defense. Thank you very much. That's always greatly appreciated. Thank you. And we do the show every week. It is the only piece of open access content we produce every week. We make it freely available. Our members, of course, can access it on their member dashboard at Law of Self-Defense, but the general public can also access it on Facebook Live and also as a playback recording on YouTube, the Law of Self-Defense YouTube channel as well, or the Law of Self-Defense Facebook page. We do produce a lot of content every week on our website. That's limited to members. We'll talk about Law of Self-Defense membership a bit later, perhaps. But this is the one weekly show we do every Thursday, or at least most Thursdays at 4 p.m. Eastern Time. That is open access. So if that's sufficient for your interest, this is what you'd want to find. So just a quick overview of the topics. Naturally, of course, this is Law of Self-Defense, so we cover self-defense law, as you might expect. In the news and Q&A show, we cover use of force events that are in the news that have caught my attention or been brought to my attention, either by Law of Self-Defense members or by the general public. And then we do Q&A after the news items upon which I've commented. And the Q&A largely consists of questions that have been sent in beforehand to the show, either by our members or using the email show@lawofselfdefense.com. Let me pop that up real quick. Show@lawofselfdefense.com. Now, it's too late for today's show to email a question, but if you do send it to that email, we'll be glad to take it under advisement for a future show. So a quick overview of the topics we plan to cover today in terms of news items. One you may have heard of, the McCloskeys, the attorney couple out of St. Louis who had waved some guns around at a Black Lives Matter mob in front of their home and found themselves criminally charged, both initially with felonies and then subsequently with misdemeanor options added on top. On bottom, I guess, giving the jury, a prospective jury, something else to vote for when the case goes to trial. Of course, the case was never going to go to trial after the McCloskeys both accepted plea agreements to relatively minor misdemeanor charges. And now even those are gone because the governor of the state of Missouri has pardoned the McCloskeys. So I have a few comments to make about that. We have some comments I'd like to make about the rejection of the appeal by Amber Geiger at the Texas Court of Appeals. Amber Geiger, you may recall, was in 2018 a police officer in Texas who mistakenly entered the wrong apartment, saw a male whose name was Botham Jean, who she believed to be an intruder in her own apartment. She drew her service pistol, shot him, killed him, and was prosecuted and convicted of second-degree murder. She has appealed that conviction, and I have a few comments to make on that as well. Of course, if you're a Law of Self-Defense member, you'll have seen our dedicated post on that case we made just a day or two ago. It looks like it doesn't want to happen. Let's see if I can make that happen. There's the post right there. It'll be familiar to you. We did a more detailed analysis of that Court of Appeals decision. Of course, that's members only content, so you would need to be a member at the Law of Self-Defense website in order to access that particular content. We also have in the news a couple of citizens arrest items that came up One is quite recent, just from a couple of days ago in Oakland, California. A couple of years ago in Oakland, California. So not a recent one, but the video of the citizen's arrest was just brought to my attention this week. So I'd like to share that with you. And another one was of a citizen's arrest that occurred just in the last few days in the Nashville, Tennessee area. So I'd like to share the details of those with you and provide some cautionary insight into the legal and, of course, physical hazards of engaging in citizen's arrest, the increasingly dangerous legal hazards of engaging in citizen's arrest, certainly in some states in particular, but I think we'll find it's generally applicable to more and more states. I was also, this was sent in as a question, but it really touches on news items, to provide an update on the Ahmaud Arbery trials. Ahmaud Arbery, of course, was shot in a confrontation with the father and son McMichaels and Roddy Bryant after he fled from an apparent burglary of a home in Georgia, and they sought to question him about his conduct. While they were armed, they pursued him. Confrontation ensued. He charged them, got shot and killed in that encounter. They've now been charged with various felonies, including felony murder. So I'll provide an update on what's going on with the Arbery trial. Also an update on what's scheduled for the Rittenhouse trial. Kyle Rittenhouse, of course, being up in Kenosha, Wisconsin, defended himself with an AR rifle against 3 serial attacks upon his life. So I'll update on that. And also I was asked to update on the event that took place this past April, where a Columbus, Ohio police officer shot a young black woman just as she was about to stab another young black woman. So what's happening with that case? That was Officer Nicholas Reardon, who fired that shot in the course of protecting a citizen about to be stabbed. So I'll provide an update there as well. And then we have a number of questions that were sent in to us for our consideration beforehand. One involved the prospect of using deadly defensive force, a pistol, for example, that you're carrying, a firearm, in defense against a paintball gun attack. What are the legal dynamics around that? Another question about, and these come up all the time, about the legal reality that under most circumstances, a barehanded attack, a thrown fist, is not going to be perceived by the legal system as a deadly force attack against which deadly defensive force can be used, meaning your concealed carry pistol, for example. We'll talk about the legal dynamics around that again. Another question that was sent in has to do with when you're faced with a criminal offense, such as a robbery, but it's unclear if it's a robbery or a criminal offense that threatens death or serious bodily injury, or indeed any injury at all, and the legal dynamics around what would have to be in place, what evidence would you have to see in order to be justified in going to deadly defensive force. We also have a question about a very related question, overlaps with the previous question quite a bit, but what if you're faced with a felony and you're in a state, and many states have these laws, you're in a state that allows for the use of deadly defensive force to resist a felony, but does that apply to all felonies or only some felonies? And how should you think about those dynamics? We had another question sent in about training. In this particular case, a retired law enforcement officer who does qualifies annually for his LEOSA permit, if that's what we call it. LEOSA is a federal statute that allows retired law enforcement officers who meet certain conditions to lawfully carry concealed in all 50 states. The question is, can that qualification or can any kind of training really be used against me in court? And we'll talk about what that means. So that's our quick overview. We'll obviously cover each of those in detail as we go through the course. Before we dive in, however, I do, of course, want to mention our sponsor. Our sponsor of today's show is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. They, in effect, promise to pay their members' legal expenses if the member is involved in a use of force event. And those expenses start big and get bigger fast, folks. Imagine you're in a situation where you feel threatened, you draw your legally carried concealed carry pistol. You don't fire a shot. You don't hurt anybody. You present the gun, and that solves the threat against you. And then you find yourself charged with aggravated assault with a firearm, because that conduct checks all the boxes for felony aggravated assault with a firearm. Good, typically for 10 to 20 years in prison, unless, of course, you can justify it as self-defense, which you may need to do a trial. And if you are charged with that kind of felony, you're easily looking at $30,000 to $50,000 in a retainer to your lead counsel for pre-trial work, folks. It doesn't even cover trial work. If you've actually shot someone in self-defense and they've died and you're charged with manslaughter or murder, it's very easy to go through a couple of $100,000, $200,000 pre-trial, folks. So unless you have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be very helpful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought. And that's as if the rest of your life depended on it, because it really does. And that's what CCW Safe does for its members. Now, there are a number of companies out there that purport to offer similar services. I've looked at all of them, as you might imagine. Some of them are okay. A lot of them suck. You don't want one of the sucky ones, I can assure you of that. And having looked at all of them, I determined that CCW Safe was the best fit for me. I'm personally a member of CCW Safe. My wife, Emily, is personally a member of CCW Safe. Now, the fact that they're the best fit for me doesn't necessarily mean they're the best fit for you, but I do encourage you to take a look at what they have to offer so you can make that decision for yourself in an informed way. And you can learn what they have to offer by pointing your browser after today's show to lawofselfdefense.com/CCWSafe. And if you do decide to become a member with them at that URL, lawofselfdefense.com/CCWSafe, you can save 10% off your membership with them using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay, so let's now begin to dive into each of these news items that I wanted to touch on and provide a little bit of what I hope will be insight on each of these. Now, one of the first of these is the welcome news of the pardon of Mark and Patricia McCloskey in St. Louis. I've already described the background of their legal challenges around having waved a couple of guns outside their home when a bunch of Black Lives Matter protesters breached the private street in front of their home, broke down the gate, purportedly threatened their home with arson, threatened them with death. In any case, they were standing out in the front yard with the guns as pictured here. Mark with an AR pattern rifle, Patricia McCloskey with something that looks like a Walther PPK. I forget whether it was a Walther or one of the many imitations of the Walther PPK. In any case, they found themselves charged with felonies, essentially aggravated assault with a firearm, although Missouri uses a different language for that particular statute. They were looking at, I believe, up to 4 years in prison. They ultimately accepted a plea deal to relatively low-degree misdemeanors that would not threaten their civil rights, right to own a gun, for example, would not threaten their law license. So they took that plea deal, and now just a few days ago, the governor of Missouri has, as promised, pardoned them, so they don't even have those misdemeanors on their record. They've been cleared of all criminal liability for this event, and that's good news. Now, they could have been a lot more prudent, in my opinion. I think they would have been a lot better off if they'd stayed inside their home and prepared to defend it rather than gone outside the home in a rather provocative stance that led to their legal woes. I think they would have been better off also if they'd had security cameras on their home facing outwards so that they had their own video footage of the event, as opposed to being limited to the video footage of the people who were opposed to them being the only thing in record. For example, they claimed that they were being threatened with death, their home threatened with being burned to the ground with them in it. It would have been helpful to them from a legal perspective if those threats were captured on video, and perhaps they were captured on video, but all the video of the event was possessed by their opponent. So it certainly wasn't going to come to light if any of that video was favorable to them. But the the broader issue I wanted to touch on here was that obviously, as we noted, they were pardoned by the governor. Folks, not everybody gets pardoned by the governor. Not everyone who probably ought to be privileged to a pardon is pardoned by the governor. Only if you're very high profile, if the governor happens to be favorably disposed to your position. Does anybody think a Governor Andrew Cuomo would have pardoned these two people in the state of New York? Absolutely not. So they're very lucky that their governor happened to be someone who was inclined to grant them a pardon in this case. They're very lucky that the George Soros funded prosecutor in this district, who originally brought felony charges against them, conducted herself so egregiously in the case that she was kicked off the case, not just her, but her entire office. So they were very fortunate that their opponent was as intellectually limited as she turned out to be, and got herself and her entire office kicked off the case. It was only that event that even made it possible for them to plead to misdemeanor charges as opposed to going to trial on felony charges. And folks, whatever you think of the merits of their actual conduct, the legal merits of their actual conduct, if you go to trial and you're in front of a jury, there's at least a 10% chance you're getting convicted, no matter how innocent you are. That's just part of the noise in the system. That's a risk of how dangerous and unpredictable juries are, especially when they're subject to the kind of political pressure that would certainly have been brought in this particular case. So they got very, very lucky. And they got particularly lucky in that they didn't actually have to shoot anybody. Now imagine if one of those people in the crowd had been a lunatic willing to die for their cause and had rushed the McCloskeys, and the McCloskeys had shot and killed that person on their front lawn under video. You think even a favorably disposed governor would have been inclined to pardon charges under those circumstances? And if you think for a minute that the fact that everything the McCloskeys did might arguably have been completely lawful, including, by the way, the firing of the shot in self-defense against the charging attacker, and there was good reason to believe that some people in that crowd were armed with firearms, that would have prevented them. The legal merits of their defense and use of force would have prevented them from being prosecuted. Well, please don't think that, because these prosecutions are often brought not based on legal merit, but based on what political capital can be gained for the prosecutor who brings the case. So then they would have been looking at murder or manslaughter charges. And the moment they went out in the yard with the guns, it was not up to them anymore if someone charged them and compelled them to shoot them. That was up to the other people. The people in the crowd, I think we would all agree, are unpredictable and not acting rationally and may wish to be a martyr for their cause, especially if they can do so and end up putting you in prison for the rest of your life because you got convicted at trial of murder. So let's use good judgment, folks. Simply being in the legal right does not mean you won't go to prison for the rest of your life. Make sure the risks you're incurring, the legal and physical risks you're incurring, are worth the benefits you're likely to get. Okay? Make sure that the juice is worth the squeeze. If they'd stayed inside their home and someone had broken the door to their home to get in and they'd killed that person, there wouldn't even be a prospect of a prosecution. But because of how aggressively they conducted themselves, even if legally permissible, it created a lot of legal vulnerability for them that they need not have incurred. So think these things through is my advice. The next item I wanted to touch upon was Amber Geiger. She was convicted of second-degree murder in the killing death of Botham Jean. And of course, the first thing I want to say up front is no matter what you think about this case, it's unquestionable that Botham Jean did absolutely nothing to justify his shooting. He did nothing wrong. He was in his own apartment. He was completely innocent in this case. Now, that granted, that does not necessarily mean that her shooting of him was, in a legal context, murder. It could have been reasonable self-defense. That's certainly the argument that was presented to the jury at trial. It was uncontested that Botham Jean was in his own apartment, that Amber Geiger walked into the wrong apartment, believing it was her own, genuinely believing that she was facing an intruder in her own home. For purposes of her self-defense argument, her justification argument for the shooting death of Botham Jean, The question is not, was she genuinely facing a deadly force threat against which she could use deadly defensive force? We all agree that wasn't the case. Botham Jean was not a deadly force threat to her. But that's not the legal question for purposes of self-defense. Self-defense does not require you were actually facing a deadly force threat. It requires that you reasonably believed you were facing a deadly force threat. So the question in her case was, well, did she reasonably believe? Was her belief, her genuine belief that she was facing a deadly force threat, which I think we agree. I don't think anybody believes she maliciously intended to simply murder Botham Jean. I think we all agree she had a genuine belief she was in her own apartment facing an intruder. The question is, was that belief a reasonable belief under the circumstances? And that's the argument that was presented to the jury, and the jury convicted her of second-degree murder. So obviously, they did not accept her self-defense narrative, or to put it more accurately, they unanimously believed that the state had disproven that self-defense narrative beyond a reasonable doubt, had disproven the possibility that her misperception of the threat was a reasonable misperception. So she got convicted of second-degree murder. I will mention in passing that, in my humble legal opinion, this was always really more of a manslaughter case at best, not really a second-degree intentional murder case. But even though she got convicted of second-degree murder, her sentence, which was 10 years with possibility of parole after 5 years, is much more like a manslaughter sentence than it is a intentional murder sentence. So in effect, it's as if she got convicted of manslaughter rather than murder, it appears to me. And of course, that's within the purview of the judge who does the sentencing in the case. But the reason I wanted to touch upon this case was because I think it illustrates, and this appeal that was just rejected by the Court of Appeals of Texas, illustrates the limits of what's possible on appeal. So in my experience, a lot of lay people who are not involved in the professional aspects of the law, often perceive an appeal of a conviction as if it was a second bite at the apple, almost like a second trial. Well, sure, the person maybe got screwed at trial, but they'll have a second chance on appeal. They'll be able to appeal those issues. As if the appeal has all the same possibilities and all the same legal thresholds favorable to the defendant that the defendant enjoyed at trial. And it could not possibly be more different, folks. At trial, the defendant is presumed to be innocent until proven guilty beyond a reasonable doubt. Every legal presumption is in their favor. On appeal, if you're on appeal, it's because you've been convicted. Well, now the presumption is that you're guilty. The jury convicted you, and now all the legal presumptions are against you, folks. Also, a lot of stuff is off the table. So you might argue some evidentiary issue at trial, for example. A piece of evidence should be admitted or should be suppressed, not heard by the jury at trial. And you make these arguments in front of the judge, often in a pretrial context, and the trial judge makes decisions about, he acts as a gatekeeper about what evidence the jury will get to see and not get to see. Folks, those evidentiary decisions will almost never be touched by an appellate court. They will defer almost entirely, unless there's an egregious abuse of discretion by the trial judge. The Court of Appeals will defer almost entirely to the trial judge on those evidentiary decisions, and those decisions can make or break a case all by itself. And the reason the Court of Appeals does that is because they have a different role than a trial court. Trial courts are hearing evidence, seeing witnesses, hearing testimony, forensics reports, all that kind of primary source evidence. Appellate courts don't see any of that, not as primary source evidence. They get transcripts of what happened at the trial, but they're not hearing witnesses. They're not hearing testimony. They're not having an opportunity to observe a witness and assess their credibility. The appellate courts don't get any of that except for transcripts of what happened, which obviously is not the same. And they don't want to have that job. Most appellate court judges used to be trial court judges. When they were trial court judges, they had that job. Now they're appellate court judges. They have a different job, and they don't want to redo the work of the trial court. So they generally will not touch evidentiary issues, again, absent some really egregious abuse of discretion by the judge, and that's a very high threshold. Also, whatever findings of fact are made at trial by the jury are, again, almost never touched by the Court of Appeals. Remember, the Court of Appeals does not see evidence, does not hear witnesses, does not assess credibility. The jury does all that. The jury is the finders of fact. In this particular case, the core question was Amber Guyger's perception that she was in her own apartment, her mistaken perception that she was in her own apartment, was that mistake a reasonable mistake? If it was, she still had a viable claim of self-defense, because self-defense doesn't require perfect decision-making. It allows for mistakes so long as the mistakes are reasonable mistakes. So if her error was reasonable, even though Botham Jean did nothing to deserve being shot, it could still be a justified shooting if the mistaken perception of being in her own apartment was a reasonable perception. Well, we know the jury didn't buy that argument because the jury convicted her. If they had bought the reasonable mistake self-defense argument, they would have acquitted her on the basis of self-defense. So we can infer that because they convicted her, they rejected the mistake as being a reasonable mistake. Well, the Court of Appeals is not going to reassess that. They're not going to replace the jury's verdict or the jury's finding of fact that the mistake was not reasonable with their own opinion and grant her a new trial or dismiss the conviction. That's just not going to happen, folks. So it's a cautionary tale. Whatever you're going to win on these issues, evidentiary rulings, findings of fact, you have to win at trial. If you don't win at a trial, there is no second bite of the apple. Those are not the kinds of things that an appellate court is going to overturn. Again, absent really egregious misconduct at trial, which is a threshold that's almost never met. Then I wanted to touch upon a couple of citizens' arrest issues that were brought to my attention this week. One of them involved this poor guy. Now, this is actually an event from 2017. I believe this occurred in Oakland. These are some construction workers tying and taping this poor dude to scaffolding. After having called the police, they're waiting for the police to arrive. They're securing him. They're making a citizen's arrest, and they're doing that because they found this guy rummaging through their construction site pickup truck, presumably with the intent of stealing stuff from the truck. Now, I have a full video of this. I'm not going to play the video because it's not that noteworthy. It is rather funny. I will embed the video in the text version of today's content if you'd like to see it. It's only a couple minutes long, but it's just video of this guy getting tied up to the scaffolding. Of course, he says he was just curious about what the inside of the truck looks like. He wasn't trying to steal anything. I can tell you, folks, as someone who long ago, when I was a young man, worked as a diesel mechanic, we used to have people walk right into our shop, which the garage doors were a good 50 feet away from the street. It was all fenced in. They would walk in past the fence, walk into our shop, pick up tools off the ground if we'd left to go get a part from the parts department, and just walk out with the tools. Sometimes they forget where they stole it from and come back to our own shop to try to sell our tools back to us. So this kind of thing does happen all the time. Theft from construction sites, from mechanics shops is a very, very common occurrence. But in any case, they caught this guy and tied him and taped him to the scaffolding, waiting for the police to arrive. Again, if you want to see the full video of all this, I'll make it available. There was also another event in the news. I don't have video of it, but it was a more recent citizen's arrest case, happened in just the last few days out of the Nashville area. This involved a gentleman who was at night walking from car to car, pulling on the car handles to see if they were unlocked so he could presumably steal property from inside the cars, if not steal the car itself. And someone in the neighborhood saw this happening on their security cameras, went out with a gun and held this guy at gunpoint. Now, I'm going to talk mostly about the legal risks of the citizen arrest stuff, the growing legal risk, but it's also worth mentioning, of course, the physical risks, because in this particular case out of Nashville, when the authorities did arrive on scene, they found that the suspect had a gun on his person. He had a gun in his front pocket. Of course, it was a stolen gun, but it was a gun in his front pocket. And he was wearing ballistic soft body armor, folks. For a car thief wearing body armor. Why? Well, maybe he figured if you're a car thief in Nashville, you're likely to have incoming rounds. Probably not an unreasonable expectation. In any case, he was held at gunpoint until the police arrived. And as often happens in the news reports, of course, all the people making the citizen's arrest they're good guys, right? They're sheepdogs. They're doing the right thing. None of them find themselves in any legal trouble. It's all hurrah, hurrah. The bad guys are taken into custody, likely to be released on their own recognizance rather quickly, as increasingly happens these days. But the people who made the citizen's arrest, it's all good for them. Well, folks, here's something to keep in mind. Increasingly, we see these citizens' arrest laws not being respected or being outright repealed. I mentioned earlier we were going to provide some updates on the Ahmaud Arbery trial. This was Greg and Travis McMichael and Roddy Bryant who observed Ahmaud Arbery fleeing from a home that they had reason to believe he had entered to commit a felony, which is felony burglary under Georgia law. They had been told by the police to keep an eye on the house and call them if they saw something suspicious. They did, in fact, call the police. Then they got in their vehicles while armed and pursued Arbery, they say, to question him about his conduct inside that home, his flight from the home. Ahmaud Arbery ultimately would charge them, fight them for possession of a shotgun, and in the course of that fight would get shot and killed. Now, there's a good case to be made that everything the McMichaels did, every step of that process, was legal under existing Georgia law. Georgia law allows for a citizen's arrest if you have a reasonable belief that someone's in flight from a felony. Now, that law is no longer on the books. It's been repealed. Today, Georgia effectively doesn't have a citizen's arrest law, period. It has a very limited merchant's right to restrain a shoplifter for authorities. But as far as a generalized citizen's arrest law, it does not exist in Georgia anymore. That statute, that 160-year-old statute, has been repealed. But arguably, their effort, and of course they say we weren't even making a citizen's arrest, and they in fact never arrested him, literally arrested him. They say they wanted to ask him questions, and certainly if you're allowed to arrest, and arguably they were, if you're allowed to actually physically arrest, you're allowed to ask questions. That would be a necessary precursor, practically, to making a citizen's arrest. It's certainly a lesser restraint of liberty than an actual physical arrest. But in any case, their pursuit of Arbery was arguably perfectly lawful under Georgia's existing citizen's arrest statute. Now, you may not like the statute. You may think it's overbroad, but that's what it said at the time that they pursued Arbery. Now, as I mentioned, it's since been repealed. And with no citizen's arrest on the books, you can end up charged with what the what the McMichaels are actually charged with. They've been charged with attempted felony unlawful imprisonment, or what Georgia calls false imprisonment. If you're interested, that's statute 16541. I'll embed that in the text version of today's content. And it simply reads, a person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. Now, the previously existing citizen's arrest law, the citizen's arrest law on the books when the McMichaels pursued Arbery, would have provided the legal authority needed to not be charged under the statute. In fact, arguably, it does provide that legal authority. That certainly will be the legal defense at their trial, that they were privileged to make a citizen's arrest under Georgia's then existing citizen's arrest law. But that citizen's arrest law doesn't work anymore. So there is no legal authority, folks, unless I suppose they happen to be a police officer. But for purposes of citizen's arrest, there is no citizen's arrest. So if you, in violation of a personal liberty, arrest, confine, or detain someone in the absence of a citizen's arrest law, at least under Georgia law, the law of many states, you'll have committed false imprisonment. And under Georgia law, that's a felony good for 10 years in prison, folks. So you think you're detaining someone you believe has been committed a crime. Maybe you saw them commit a crime. Maybe they actually committed the crime. They shot the store clerk in front of you. And now they're fleeing from the scene. And you want to make a citizen's arrest. Are you sure you have the authority to make a citizen's arrest without committing a 10-year felony in the process? Because if you're not sure, people often ask me, they'll send me videos about some poor innocent person being victimized. And they'll say, why didn't anybody step in? Why did all those people stand around and do nothing? Well, folks, this is one of the reasons. Because the risks, not just the physical risks, but the legal risks are increasingly enormous. And you may not be treated as a hero for having stepped in. In fact, you may think you were doing the right thing, being a good citizen, and find yourself charged with felony murder and the risk of spending the rest of your life in prison, a good risk of spending the rest of your life in prison for having engaged in conduct that you think was the right thing. So again, approach all these things with caution. Now, in terms of the updates on these trials, the Ahmaud Arbery trial being the trial of the McMichaels and Bryant, for your calendar, jury selection in that trial is supposed to begin October 18th. That's a Monday, October 18th, which means I would expect jury selection to take about a week. I mean, it could be much longer or shorter. There's no way to predict. But I'm expecting jury selection will take about a week, and that the trial proper, opening statements, will probably occur around the next Monday, which would be October 25th. The other trial I was asked to provide an update on was the Kyle Rittenhouse trial. That's currently scheduled to begin Monday, November 1st, which is only 1 week after I expect the Ahmaud Arbery trial to really get going, the trial proper. So it may well be that these two trials overlap. It would not surprise me if the Ahmaud Arbery trial took 2 or 3 weeks. And it only really starts a week before the Rittenhouse trial, so it may overlap with the Rittenhouse trial. That doesn't have any implication for the trials themselves, but it may have implications for my coverage of those trials. Normally, these high-profile cases I cover in real time, every day, watching every minute of the trials, assuming they're televised, and I expect both of these trials to be televised. But obviously, I can't do that for 2 different trials simultaneously, so we'll have to kind of play that by ear as well. See how that works out. And the other case I was asked to give an update on was the case involving Columbus, Ohio officer Nicholas Reardon. He shot Micaiah Bryant, 16-year-old Micaiah Bryant, back in April of this year. He showed up at the scene in response to a call about a fight. Apparently, Bryant was fighting, and not that it should matter, but this is the world we live in. Micaiah was apparently involved in a fight with, and Micaiah Bryant was a young black woman, 16 years old. She was apparently involved in a physical confrontation with another young black woman, and no sooner had Officer Reardon stepped out of his patrol car to assess what was going on than Bryant stepped forward, knife in hand, swinging at the other participant in the confrontation, attempting to stab her. Obviously, a stabbing with an edged weapon is a use of deadly force. There was no facts and evidence from which that use of force could have been considered defensive in nature. The other girl was apparently unarmed and simply about to be a stabbing victim. And Reardon drew his service pistol, shot Micaiah Bryant with fatal results. And I'm not going to play the video of that event here. We have the video of that event. But when I put it on these Facebook Lives, Facebook gets upset about the violence in the video. I will embed the video in the text version of today's content, which you can find later today. It takes a couple hours to do post-production, but I'll embed that in the text version of today's content over at lawofselfdefense.com if you'd like to see that video, if you haven't seen it before. It pretty clearly evidences a lawful use of deadly defensive force by Officer Reardon in defense of another, in defense of the young black woman who is about to be stabbed. And there was a lot of news coverage of this at the time it happened. So it occurred April 20th, 2021. And if you Google Nicholas Reardon or you Google Micaiah Bryant, you'll see a bunch of news coverage April 20th, 21st, 22nd, and then the news coverage disappears. As far as I can tell, it disappears until the first week of July. Then I found a brief notice that the case had been sent to the Franklin County prosecutor, that the relevant prosecutor for that Columbus, Ohio area, for his consideration, reviewing whether charges should be brought against the officer. And since then, there's been absolutely nothing. In fact, if you go to the prosecutor's website and do a search on Reardon's name, or Bryant's name for that matter, what you'll see is this. because I did the search today. No results found. So he's done absolutely nothing public with this matter at all. And I don't expect there to be anything public with this case, because the two people involved in the confrontation were both young black women. The officer, I don't even know what his race was. Again, not that it should matter. But to the extent he shot a black woman with a use of deadly force, it was done in defense of another young black woman. So we don't have the kind of racial political capital involved in this case that we see in many of these high-profile cases. So I expect Officer Reardon isn't going to face any criminal liability in this case. I think they'll just let it remain silent until not much happens, until it's off the radar screen. It's been overcome by other events, and that's my expectation. So if that changes, obviously, I will report upon it. So those were all the news items I wanted to touch upon. We do have a bunch of questions, probably more questions than we can get through today. If you sent in questions for today's show, especially if you're a Platinum member and I don't get to it today, I will roll those over to next week. If I do get through all the questions today, I will, before the top of the hour, we try to keep the show to an hour, I'll scroll quickly through the comments in the membership dashboard at lawselfdefense.com and on the Facebook live broadcast and answer additional questions in those comments as time permits. Can't promise. So Ken, who's one of our Platinum members, sent in a question noting that there's been recent drive-by attacks by people using paint guns. Am I allowed to use deadly force to prevent permanent injury to myself and others? Well, it's kind of a complicated question. First of all, generally speaking, paintball guns are not guns that inflict death or serious bodily injury. Now, yes, I know I've participated in events with paintball guns. At close range, they can leave a welt. The question then becomes, is a welt serious bodily injury that other people, remember, this judgment call is going to be made by people other than you. Is a welt left by a paintball gun a sufficiently serious injury that it would justify your shooting that person in the face with a gun? Because that's what you're actually asking. They're shooting me with a paintball gun. Can I use deadly defensive force to neutralize that attack? And I would suggest to you that in most jurisdictions, if you know it's a paintball gun, what you're defending yourself against is a paintball gun. You're aware of that. You just don't want the welt, and you shoot that person in the face and kill them, that you should expect to be criminally charged. Now, you may be able to convince a jury that a welt is sufficiently serious bodily injury that you were privileged to shoot and kill that person, but that's not a case I would want to be defending. It gets more complicated, of course, if you don't know that it's a paintball gun, if you perceive that instrument to be an actual firearm. In other words, it sufficiently resembles a real gun that you believe you're defending yourself against a real gun. Well, then you have a genuine perception that you're defending against not a welt, but deadly force, a firearm. Then the question becomes whether your perception of that as a real gun is a reasonable perception. And if it is, under the circumstances, well, then you have a viable argument for self-defense. Again, like we talked about with the Amber Geiger case, self-defense law does not require that you be defending against an actual threat. It requires that you be defending against a reasonably perceived threat. If someone threatens you with a fake gun that looks real under the circumstances, that's a lawful use of defensive force, so long as your perception of that object as a real gun was a reasonable perception. And folks, if someone carves a bar of soap into something that looks just like a real gun, that a reasonable person would perceive as a real gun, and they threaten you with that bar of soap that looks like a real gun, you can be justified in using deadly defensive force against that apparently real gun. And if that would apply to a bar of soap, it would obviously apply to a paintball gun, if that paintball gun were to be similarly reasonably perceived as a real gun. But remember, whether your perception of it as a real gun was reasonable is not ultimately a function of your judgment. Other people are going to be making the judgment call about whether or not that was reasonably perceived as a real gun. The cops, the prosecutor, the jury, the judge, it's their judgment of whether or not it was reasonably perceived as a real gun that's going to control your own fate, not your judgment. So again, you're putting your life in the hands of other people who, in an ideal sense, in a criminal justice system, would be unbiased against you. But in today's politically charged criminal justice environment, I would not count on the system being unbiased against you. We see more and more politically charged prosecutions and use of force cases all the time. So Fritz sent in several questions. Let's see how many of these I can get to. Some of these kind of overlap. One involved the use of fists not being deadly force. So generally speaking, a barehanded attack upon you is not going to be deemed to be deadly force by the courts. Most barehanded attacks do not inflict death or serious bodily injury. Therefore, a mere barehanded attack, absent aggravating factors, won't be sufficient to justify your use of deadly defensive force. But what about if I could be knocked out? What about if I'm armed with a gun and if I'm impaired by that barehanded attack, they could grab my gun and use it against me? And all that is true. All that happens in the real world, right? The issue is, one, you can't speculate that that's going to happen. You have to have some indication that it's happening. If you feel someone reaching for your gun, that's a reason to believe they're reaching for your gun. But the mere possibility, it could, it might, it should, it can speculatively happen is not a reason, before there's any actual evidence from which you can infer it happening, for you to shoot someone in the face who shoved you, for example. Also, a lot of times these questions, and these are among the most common questions we get because we're all concerned about a barehanded attack. We all know barehanded attacks, although they're unlikely to kill or cause serious bodily injury, sometimes do. We've seen the knockout punch videos. Barehanded attacks sometimes do kill and maim people. None of us want to be killed and maimed. But often the answer to that predicament is not going to your gun, folks. Whenever I get these questions, I always wonder, where is this person's, the questioner's, non-deadly defensive force option? Do they have one? Is the only defensive tool at their disposal a gun? Or do they have pepper spray? Do they have bare hand skills themselves? Do they have something to counter a non-deadly force attack with, to neutralize that attack, perhaps keep that attack from escalating to a deadly force level, other than going to their gun? Because we may wish we lived in a world where someone could throw a punch at your head and you could shoot them in the face, but that's not the legal world we live in, folks. So if they get past your pepper spray, if they get past your non-deadly defensive techniques that you've attempted to deploy, bring into use, and they're still attacking you, well, that's a very different fact scenario than if you were shoved and then you shot them. So don't put yourself in an unnecessarily vulnerable position by having too restricted a self-defense toolbox. Have those non-deadly defensive force options. Tony L., also a Law of Self-Defense member, says, well, what about if you're the subject of a felony and you live in a state that says, well, you can use deadly defensive force not just to stop death or serious bodily injury, but to stop a felony being committed upon you? What about an unarmed felony, like a strong arm robbery, for example? There's no weapon being displayed. In other words, there may be force threatened, but it's not necessarily deadly force. Because if you're threatened with deadly force, well, then you don't need to worry about the felony authorization to use deadly defensive force, right? If you're threatened with deadly force and you meet the other conditions of self-defense, you're privileged to use deadly force in self-defense. So we don't need to worry about that scenario. That kind of answers itself. The more complicated scenario is you're not being threatened with deadly force. You're being threatened only with non-deadly force, or maybe not with any force imminently, but you're arguably the subject of a felony, like a strong arm robbery can be a felony. And you have a statute in your state that says if you're the victim of a felony, you can use deadly defensive force to stop that felony. A number of states have those statutes. Folks, it's one of the risks of relying only on statutory language to understand your state's use of force laws. In every state of which I'm aware, and as you might imagine, I've looked at all of them, these deadly defensive force to prevent felonies either enumerate the felonies, list the felonies, and then they're all felonies that have baked into the cake an element of deadly force. So they're armed robbery, they're forcible rape. Okay. Or even if they don't enumerate it, so you don't have this handy list, the case law, the court decisions in that state will say, hey, this doesn't apply to all felonies. This applies to felonies that actually represent some deadly force threat, meaning a threat of death or serious bodily injury. Because we live in a world, a legal world, full of felonies that don't involve any threat to persons. So someone writes a bad check over a certain dollar amount, that's a felony. But that doesn't mean you can use deadly defensive force upon them. I mean, you might want to, if it's a big enough bad check, I guess. But you're not privileged to under the law, even though they're committing a felony. So even in the context of using defensive force to protect yourself against a felony, keep in mind, the expectation is going to be that it's a felony involving force and perhaps even deadly force. So if you're planning to rely on that kind of statute in your state, make sure you read not only the statute, especially if it has an enumerated list of forcible felonies, but also the case law, the court decisions that interpret and apply that statute. Because if all you've read is the statutes don't necessarily mean what they appear to say, folks. Statutes passed by the legislature by themselves have no effect in the real world. They don't have an effect in the real world until they're interpreted and applied by courts. So if all you've read is the statute, but not read how they're interpreted and applied by courts, I strongly suggest you don't really know what that statute means, because it doesn't necessarily mean what the apparent plain English words would suggest it means. And then finally, just a few minutes left, we had a question here from Tom O., also a law self-defense member. He's apparently a retired law enforcement officer taking advantage of the federal LEOSA statute. This statute says that retired law enforcement who meet certain conditions, and in particular take some annual qualification training, undergo annual qualification. I don't think there's a training component, but they have to show up at the range and shoot some course of fire and meet certain criteria, that those officers will then be licensed to carry concealed under this federal law that applies in all 50 states. So basically, it's a national concealed carry permit. And he asked, well, if I do this annual requalification, can this be used against me in court? And really the question, as I would rephrase it, applies to any kind of training, especially defensive training. If I take a shooting course, a knife course, any kind of course, if I do martial arts, if I compete with firearms, if I get any kind of qualification or certification involving a use of force skill or tools, can that be used against me in court? And the answer is a little bit complicated, because first we have to ask, what do we mean by used against me in court? Do we mean, can a prosecutor talk about it in court in an attempt to make you look bad? And the answer to that question is almost invariably yes. Prosecutors can talk about anything, practically, to try to make you look bad in court. The real question is, how likely is it to be damaging to you, and how easy or difficult would it be for your defense counsel to rebut that attack by the prosecutor? And the ones that would be difficult to rebut, the arguments by the prosecutor centered around your training or qualifications that would be difficult to rebut would be, one, if the training you took sucked, if the training you took was bad, taught you to do things wrong, taught you to do things that are not legally sound, and then you did those not legally sound things, well, the law doesn't really care what your training was per se. They care about what you actually did in the event. And if what you did in the event was not legally sound, nobody cares that you were trained to do that. So the bottom line there is, don't get bad training. Make sure you're getting training from qualified, legally sound people or institutions. And they exist. They're out there, folks. Unfortunately, there's a lot more trainers out there without a good foundation, at least in the legal elements of use of force law, than there are good ones. So not everybody with some kind of self-defense or firearms training certification knows what they're talking about. In my experience, most of them don't know what they're talking about, at least in terms of the legal dynamics. So please go to ones that do. So first, get good training. Second, when you get that good training, if you got legally sound training and then in the moment you nevertheless violate that training and engage in conduct that is not legally sound, well, that's not going to help you. If what you did was not legally sound, you've made yourself legally vulnerable to prosecution. And it doesn't matter that you had good training if you didn't follow the good training. So get good training and then follow the good training. If you do that, then all the prosecution can really do is make rhetorical arguments, emotional arguments about your training or competition experience, and he'll probably be allowed to do that. And it may be uncomfortable, but it's not likely to cause the kind of substantive harm to your legal defense that either following bad training or violating good training would have done to you. So get good training and then conduct yourself within the boundaries of that good training. Don't violate the own good training you got. And by the way, certainly, folks, if you got good training and you violate it, that looks horrible. Now, sometimes people will say, oh my gosh, now I'm scared of getting training. That's not the right answer, folks. The answer is not to not get trained. If you're not trained, you're less capable of defending yourself. At the end of the day, you have to win the physical fight before you can be concerned about the legal fight. So get good training. Make yourself harder to kill. That's more important than anything. If you don't survive the encounter, then all the legal issues are moot. So get good training. Make yourself more capable. But then make sure that you adhere to that training. That's the right answer, okay? Not to get trained. All right, folks, we're right up against about a minute left, maybe 2 minutes left. Let me scroll through the comments quick. James on the Law Self-Defense membership site seems to be telling us that the officer involved in the Bryant shooting was white. That could be. It was kind of hard for me to tell from the video. I mean, personally, I don't care what race he was. I think it was good decision-making either way. But of course, in the world we live in, that can be a factor in whether or not these cases are prosecuted or not. Let's see. Jack asks, in the context of a non-deadly force attack and the use of deadly defensive force, how much disparity of force do we need to justify deadly defensive force? I'm 5'10", 215 pounds. Am I expected to trade licks with a 6 foot, 300-pound athlete, especially since I'm 74? So all those facts, folks, come into play in terms of your narrative of defense. There's no black and white answers here, ever. So what you'll argue is, hey, I was attacked by a guy much larger, much stronger than me. I'm weaker, not as strong, much older, much more prone to injury, don't have a particular fighting skill. This guy appeared to have exceptional fighting skill. Those are all facts you would put on the table, that your lawyer would put on the table, to support your narrative that there existed a reasonable likelihood that this barehanded attack had those aggravating factors that leveled it up to an attack that could readily cause you death or serious bodily injury. That's the fundamental question. Is there something about that attack that's likely to inflict death or serious bodily injury? If the answer is yes, and it could be the opponent's size or numerous opponents, disparity of numbers, or their strength, or their exceptional fighting ability, or your unusual frailty or susceptibility to injury, perhaps because of age. I'm not as young as I used to be either, folks. I get it. But if there's something about the nature of the attack that makes it not a traditional barehanded attack, but an exceptional barehanded attack that reasonably can be foreseen to threaten death or serious bodily injury, well, then it's a deadly force attack against which deadly defensive force can lawfully be used. But again, it's other people making the judgment call of whether or not those factors rise to that level such that the barehanded attack is reasonably foreseen as being deadly force in nature. All right, folks, well, we're right up against the top of the hour. Remember, we do this show every week, so I encourage you to mark your calendars every Thursday, 4 p.m., or just about every Thursday, 4 p.m., my schedule permitting. So mark your calendars. We do it live on the lawselfdefense.com Facebook page and on the Law Self-Defense membership page. Afterwards, we do leave video replays of each show on Facebook, on our lawselfdefense.com blog. And also, we posted up on the lawselfdefense.com YouTube channel if you'd like to see it there. We also have available a free podcast version of these shows. So your favorite podcast player, whether that's Apple or Google or Spotify or whatever the case might be, get it for free. You can find out how to link to that at lawofselfdefense.com/free podcast. And if you really like this kind of content, you might consider becoming a Law of Self-Defense member. It's dirt cheap to be a member. It's only about $0.25 a day. Even better, you can try it for 2 weeks for just 99 cents. If you're not happy with it, we'll give you back 200% of your money in that 2-week period. And you can take advantage of that at lawofselfdefense.com/trial for that 2-week 99-cent trial. All right, folks, I'm going to wrap up the show for today, August 12th, 2021. I hope you join us again next week. In closing, I just remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.